Hello, everyone, and thank you for joining us for today's special ACLU Supreme Court briefing. My name is Makiba, and I will be your operator. A few quick housekeeping items. To ask a question, please use the Q&A panel available at the bottom of your screen, and we will do our best to address them during the Q&A portion later in the call. Please note that closed captioning is available. To activate, simply select the closed caption button found at the bottom of your screen. I will now hand it over to Cecilia Wong, the Director of the Center for Democracy.
Good afternoon, everyone. Good day and welcome to our call today. My name is Cecilia Wong. I am a Deputy Legal Director at the ACLU and the Director of our Center for Democracy. My pronouns are she and her. I want to start today by thanking you. We sometimes send out invitations to these webinars during these COVID stay-at-home times to our full list of 4 million ACLU members. But today we have a little bit of a more exclusive offering for you, our leadership supporters. I want to thank each one of you because you are our most stalwart, our most generous, really our leaders among our supporters. And we want to thank you for not only partnering with us through your generosity and your contributions, but also for standing with us as we take on so many fights over the past 4 years and going on into the future. So I think all of us have been breathing a sigh of relief about the election outcome. We'll all be glad to see the back of this particular president who's been so disastrous for civil rights and civil liberties. But the point of today's call is really that our work in many ways is just beginning and restarting. I want to start by saying we are talking off the record. We want to be able to speak with all of you candidly as our closest advisors and supporters and give you our unvarnished thoughts. So if we happen to have any journalists on board today, please consider all of it off the record. We're going to be talking today about what's happening at the Supreme Court with the issues that the ACLU is litigating and the issues that we're following and that we're fighting for around the country, and some other key litigation in the lower federal courts and possibly state courts. No matter who is president, we always have our work cut out for us. We're proceeding with our long-term strategies for justice and equality across our issue areas. President Trump has been something like an arsonist, setting a lot of new fires all around the country. But once he's out of the office, the work is not instantly done. There is a lot of work to be done to repair the damage and to continue the long-standing work that we've had before he was president. Today, we have 3 of my colleagues on board joining me for the call. David Cole, of course you know, is our National Legal Director. Louise Melling, who is our Deputy Legal Director and Director of the Ruth Bader Ginsburg Center for Liberty. Dale Ho, the Director of our Voting Rights Project. And we're also joined today by 2 ASL interpreters, Clint and Connie. Thank you so much, Clint and Connie. And Shanti, our closed captioner. Closed captioning is also available. So we will start with David. So bye, Louise and Dale. We will see you shortly. So David, first, I want to say congrats again to remind all of our supporters on right now. You argued successfully a case on behalf of our clients, Amy Stevens and Don Zarda, an amazing win in the field of LGBT rights, establishing that it is unlawful to fire someone for being LGBT or T. That was last term. So this term, David, what do you see right now going on in the Supreme Court? You're our chief court watcher and strategist. How has the federal judiciary and particularly the Supreme Court shifted?
Thanks, Cecilia. I think everybody on this call probably knows that Donald Trump's most lasting contribution may well be his appointments to the federal bench. He's appointed well over 200 federal court judges, 1/3 of the Court of Appeals judges across the country are Trump appointees, and of course, 1/3 of the Supreme Court are Trump appointees. And many people have sort of asked me, how are you going to get anything done before the Supreme Court with the loss of Ruth Bader Ginsburg, her replacement by Amy Coney Barrett, and a 6-3 conservative liberal split on the Supreme Court. And it's a challenge. It's definitely going to be a challenge. But what I think one way to sort of put it in perspective is to think about the fact that the Supreme Court has been conservative majority led for the last 50 years. 50 years. It was 1971 was the last time there was a liberal majority on the Supreme Court. And the ACLU has been around for 100 years. So for half of our history, we've been litigating under a conservative majority court. And think of some of the things that court has recognized: the right to abortion, the fact that discriminating against women on the basis of their sex violates equal protection, a right that Ruth Bader Ginsburg won in the Supreme Court before a conservative court, upholding affirmative action, extending trial rights, many important trial rights to criminal defendants, recognizing LGBT equality, marriage equality, striking down the death penalty for juveniles, and expanding First Amendment protections to the internet and privacy protections to the digital age. All that happened under a conservative court. So we're going to be watching very carefully this conservative court, and it's definitely a more conservative court. But I think the top line for me is there are reasons to believe that we can continue to make progress before this court if we continue to litigate in a smart and coordinated and integrated way on the issues that we care about.
Give us some inside baseball, David. You recently wrote a piece in the New York Review of Books called "Can Liberals Win in a Conservative Court?" Are there ways that the shift from the 5-4 majority to a 6-3 conservative majority will affect the ways we litigate cases, the arguments that we make in the Supreme Court? Give us some of the juicy stuff.
Yeah, so I don't know how juicy it is, but I will say, that we've already adjusted the way that we litigate in the Supreme Court. In particular, recognizing that we have a number of justices who are textualists and originalists. We make arguments based on text and original intent much more than we ever did before, because at the end of the day, if you don't convince some of those folks to come along for the ride, you're not going to prevail. So that's one way in which we have changed. Another thing that we've done is when we file amicus briefs, we file more amicus briefs in the Supreme Court. Those are friend of the court briefs, where we're not the direct litigator of the case, but we're submitting our views. That's how Ruth Bader Ginsburg primarily got women's rights recognized in the Supreme Court, was through amicus briefs. When we file amicus briefs now, I almost always look for a conservative organization to co-sign the amicus brief. And so we're filing an amicus brief this week that's being co-signed by the ACLU and the Leadership Conference for Civil Rights and the American Conservative Union and the Cato Institute. And there are, particularly in the criminal justice arena, a lot of areas where there's a bipartisan agreement, remarkably enough, in this partisan world that we live in. And so we're able to do that. So I think you need to be able to speak their language. But then I also think that you need to recognize the role that societal forces play in how Supreme Court cases come out. So, why did a conservative majority court recognize marriage equality? Not because we made really brilliant arguments in the Supreme Court, not because there were great amicus briefs filed, that's all important, but the reason that they recognized marriage equality was because there was a sustained effort outside the court for 30 years for gay and lesbian folks to come out, to identify themselves, to insist on their equal dignity, and then to seek incremental reforms in a variety of forums, whether it be corporate boardrooms, extending domestic partnership benefits to same-sex couples, or anti-discrimination ordinances in progressive cities prohibiting discrimination on the basis of sexual orientation, or amending family law to recognize same-sex parents' rights. And only after all of that progress was made was it possible to win that case in the Supreme Court. So I think we have to continue the integrated advocacy that we do, the coalition work that we do, and what political scientists have found is that the court over time rarely departs very radically from where the country is on fundamental issues. So we need to move the country on the fundamental issues, and if we do, in a progressive civil liberties and civil rights protective fashion, I don't think the Supreme Court will get in the way all that much, but only if we do.
I think of that famous anecdote where Justice Powell was someone brought to his attention, after the famously bad decision on anti-sodomy laws. He said he had never met a gay person before. And then someone pointed out to him, oh, well, you're so-and-so, your former law clerk is gay. And he had no idea. So I think about all of the progress that's been made. We're gonna let you off the hook for now and bring Dale on. Stick around for the Q&A at the end.
Thank you.
Thanks, David. Hello, Dale.
Hi.
So I'm going to start with you by first bragging on your behalf, because I know you're too modest to do it. Dale is coming off of a very recent Supreme Court argument in the second case involving a Donald Trump effort to attack immigrants through the census, the 2020 decennial census. This was Census 2. Dale won a Supreme Court case last term in the first Donald Trump attack on immigrants, in which he wanted to add a citizenship question to that census, which would have been unprecedented and was intended to chill immigrant families from participating in the census. So I want to brag about that, and we're going to talk about Census 2, now pending at the Supreme Court, submitted. But first, I also want to give you a chance to brag about the incredible work that your team in our Voting Rights Project has done around the country and around the clock in the last several months, protecting people's right to vote in the face of all kinds of challenges related to COVID and to those election officials who would want to make it more difficult. Give us the rundown. How many cases did we bring? And give us the win-loss.
Sure. Thanks, Cecilia, and thank you all so much for your continued support of the ACLU and for joining us this afternoon. When the pandemic hit, the Voting Rights Project really sprung into action. Our lives at the ACLU, our professional lives, our personal lives, just like yours, were thrown into chaos by the pandemic. And then we realized that that chaos was going to engulf our elections as well. And we saw that throughout the primaries, with elections getting postponed, polling places getting closed. And so we filed dozens of cases from the early days of the pandemic through the end of the summer, just to try to make sure that people could vote safely without having to risk their health to cast a ballot. All told, we won a total of 28 victories this year in 21 states and Puerto Rico. Those states are home to more than 180 million people and wield 285 votes in the Electoral College.
Amazing track record. Give us a flavor of the kinds of voting access problems that we were litigating about.
I mean, the first thing we wanted to do was make sure that anyone who wanted to vote by mail without having to go to a crowded in-person location to cast their ballot on election day could do so. So we filed a number of states. We filed cases against a number of states that were refusing to let every eligible voter do that. Ultimately, we won right to vote by mail for all eligible voters in 5 states, and 2 other states plus Puerto Rico, in response to lawsuits by us, expanded the category of people who could vote by mail. The one case that sticks out for me in all of this was a case in Tennessee that we brought on behalf of a 2-time cancer survivor who was immunocompromised. Tennessee's position was, if you can physically travel to a polling location, you have no right to vote by mail. So we brought this case on behalf of Ben Lay, a voter in Tennessee, and while the court refused to extend that right to all eligible voters in the state ultimately relented and permitted voters like Ben, who have pre-existing conditions that render them particularly vulnerable to COVID, to vote by mail if they so chose.
It's extraordinary work. And I just want to emphasize again, you and your team were literally working around the clock. I thought there were some weeks where I thought literally people didn't sleep. And so I'm so grateful to the Voting Rights Project. Talk about, before we turn to Census 2, your pending case at the court, talk about whether you're anticipating another red state backlash on those voting rights issues. After the 2008 election of Barack Obama, we saw a spate of basically voter suppression measures, including in North Carolina, where you had a trial victory, just a triumph. Are you expecting the same after this election of Joe Biden?
Yes, definitely. I remember about a year ago having a conversation around the office where someone asked me, if Trump wins again, are we going to see another round of voter suppression? And what I said was, actually, I think if the Democratic candidate for president wins, that's when you're going to see a backlash, particularly in close states, efforts to cut back on voting rights to prevent another victory like that from happening again, the same way that we saw after the 2008 presidential election. And we're already seeing it in Georgia, which was maybe I think the closest state in the presidential election. The Republican majority Senate has already announced their intention to get rid of drop boxes for absentee ballots, require photo ID for absentee ballots, which is kind of doesn't really make a whole lot of sense when you can't see the person who's casting the ballot. A photo ID doesn't really do much, and to get rid of no excuse absentee voting in Georgia, to return to a system where only people with a particular excuse can vote by mail. So we're in for a big fight there, and I suspect in a number of other states next year.
Yeah, I think we're expecting the same kind of red state backlash across the issues where the federal executive branch might be making positive changes, including in repro and immigration, which we'll talk about. And finally, let's talk about Census 2. You just argued it. First of all, I don't know if all of our supporters today realize that during COVID, the Supreme Court has changed the format of arguments. And each of the justices asks a question in turn. What are your reflections about that experience of doing the argument by phone? And what's your forecast for the case?
It's a really, really different experience from going to the court and arguing the case in person. Now they're all on the phone, as you said, Cecilia, and the justices ask questions in order of seniority, starting with the Chief Justice. Every justice gets a designated number of minutes with the oral advocate. So you always get questions from Justice Thomas now in just about every case. The court also has very strict limits on the kinds of phone lines you can use. You can't use a cell phone. You can't use an internet-based landline. It's got to be an old school copper landline, which I don't have at home. I've been used to, working at home basically since the pandemic began in this office. But I had to return to the old ACLU office where our great operations folks rigged up an old fax line, which uses a copper line, into a conference room with an old school telephone. And I returned to the office for the first time since New York went into quarantine in March, and argued the case there. It was a very bizarre experience. You can't see the justices' faces. You have no idea how your argument is landing. And because you get one justice at a time, you can really get cornered by one justice about the particular issue that they are particularly interested in.
So from the listener's perspective, and I was listening to your argument live, of course, you really just knocked it out of the park. You were both responsive to their questions and of course had a mastery of the subject matter, but I thought that your peroration, your closing really brought home what the real life impact is on immigrants, immigrant families, and people who are concerned about the proper, all kinds of things from appropriations to representation. So what's your forecast? What do you think the court's going to do?
It's tough because there are a lot of questions about the timing of this case. And I think it's possible that the court could decide that the case was premature. I mean, for folks who, maybe aren't as steeped in it as us, this is a case that the Trump administration, challenging the Trump administration's policy of excluding undocumented immigrants from the census count used to divvy up representation in the House. Altogether, 12 million people who live in this country. If you look at the estimates, 66% of undocumented adults have lived here for more than a decade. You're talking about our neighbors, our coworkers, our family members, and the government is just arguing that they're not persons under the Constitution who are worthy of representation. This is by far the most blatantly unconstitutional thing that I've ever had to litigate against in my career. And it's not just about undocumented immigrants themselves, although it is about them. It's about any state or community with large immigrant populations that stands to lose out on in representation in Congress and votes in the Electoral College for the next decade. I mean, this is really an attempt by the Trump administration to lock into place a distortion of our electoral system to tilt things in favor of minority power for the next decade. I was heartened by the reaction of the conservative justices who seem to understand that this is clearly against the text of the Constitution, but I do think it's possible that we could technically lose the case based on timing issues, that the justices could say, we just don't know what's going to happen here. We don't know how many undocumented immigrants the Trump administration is going to be able to identify and pull out of the census count. So come back, file another lawsuit when we actually see what those numbers look like in January. But I feel very, very confident that the court is not going to say that what Trump is trying to do here is okay and passes constitutional muster. And if things turn out the way that I expect them to, then once that policy, if it does ultimately get implemented, we'll see them right back in court.
That's right. We live to fight another day. Thanks, Dale. We're gonna wave you off and bring you back for the Q&A. And now I want to bring on my colleague, Louise Melling. Hello, Louise.
Hi, Cecilia.
I'm going to check in. I think, yes, I was going to ask. We're going to have a switch in ASL interpreters. Welcome, Connie. All right, Louise, you direct our newly christened Ruth Bader Ginsburg Center for Liberty, which encompasses our work on LGBT, reproductive freedom, disability rights, religion, and women's rights. Many of our biggest wins in the Supreme Court over the last several years have come in your issue areas. What do you see happening going forward? Obviously, the switch from Justice Ginsburg to Justice Barrett comes with a lot of trepidation for these issues. What's your take?
So I think when you're talking, first of all, nice to see you, and thank you everybody for joining. And while we have trepidation about the courts, one thing that's super clear is no matter what you think about the courts, our work in the courts is going to be robust and incredibly essential. The wins I think you're thinking of are the great headlines of Windsor, Obergefell, Bostock, sort of a glorious run with the ACLU and comrades. In the LGBT space, I feel cautiously optimistic. I think we will still be able to celebrate some wins, or that's how I'm approaching the coming years. Not everything, but some. And I say that principally for two reasons. One, Bostock was a decision 6-3, so we had a good margin going in, and for a reason David was talking about, which is social pressures. I mean, we have high public support, we have business support, and we have activism, we have Republican and Democratic support in the LGBT space, in the sense that LGBT people live in all families. And I think that makes a real difference for how people approach the issue. And I will also credit my team, the LGBT team, for being incredibly strategic. There are two big buckets coming forward for the Supreme Court right now, I think, in the LGBT space. One is in an area we call religious refusals. Think of that as institutions that say, we have a right to refuse to comply with a law. And here we're thinking about anti-discrimination laws. That's what we care about, because compliance would be contrary to our religious beliefs. There's a case of that ilk in the Supreme Court right now. The ACLU is counsel in the case. The case is known as Fulton. This is a case in which Catholic Social Services says it's entitled to a government contract to perform a government function. Here, that function is certifying foster care families, even though they refuse to comply with a condition of the contract, which is that you not discriminate. Catholic Social Services refuses to certify same-sex couples because of its religious beliefs. So I told you I was optimistic, but I will tell you in this area, it's trickier. I'm less optimistic about this particular area, given the ways in which the justices over the years in the LGBT cases have gone out of their way to say, good people have faith objections here. And they've emphasized that this is a tension. And in other cases, they're clearly being quite deferential to religious entities that say they're subject to discrimination if they're punished for not doing something. What I do feel confident about is I don't think that Catholic Social Services and our adversaries in that space are going to get what they want, which is for the court to say, the Constitution protects your right to refuse. The Constitution protects your right to discriminate. We won't have I don't anticipate a broad loss like that. I think in Fulton, there are two different things in play. One is that the court, as it did in the Masterpiece Cake Shop, that was a case that David argued in a prior term about a bakery that refused to provide a cake to a same-sex couple. The court may say, we think that the commission was hostile, that some of this was animated by hostility to religion. It wasn't just a neutral application, there was some hostility. And we also saw the justices concerned about the fact that there were other agencies, 30 agencies in Philadelphia in which you could get service, and 29 of them will serve you. Why should we really punish Catholic Social Services? So I think there's a chance we lose, but lose in a narrower way. The other bucket of cases coming up are cases about the rights of transgender people to live consistent with who they are. And we see a whole bunch of cases being teed up right now. Those cases being teed up are, for example, to have the proper gender marker on your transcripts or another document. Gavin Grimm, Gavin Grimm is potentially going back up. The right to have medical care, to receive medical care, not be subject to discrimination because of that, whether it's in the hospital system or whether it's in the insurance system. There's a case with a cert petition coming involving discrimination at a hospital. I don't think the court will take that case, but I think that case is also being teed up. Cases about whether you can participate in sports consistent with your identity. The case coming out of Idaho to ban transgender girls and women from girls and women's teams coming up. And I think in those cases, the court may understand the discrimination principles more plainly. So hoping for some good there. I think we can still make progress there.
And I'm curious to hear, are there interventions that the Biden administration can take that would affect some of this litigation on LGBT issues in a positive way? And if so, do you expect more of a state law backlash?
So first of all, it will be a glorious thing to have an administration that actually comes in on our side, to come in to say that they support equality principles as opposed to discrimination. The Trump administration has filed, for example, in the Fulton case, in support of Catholic Social Services. The Trump administration came in support of the bakery. It's coming in a whole bunch of lower court cases. So that will be a welcome difference. The Biden administration can make a change through executive action. But in this space, as well as in other spaces, whether it's voting or abortion rights, we're going to see a lot of action in the states. We'll see some positive action in the states, but we're going to see a lot of efforts to sort of challenge our rights in the states. Different states, first of all, that's what they believe in, that's what they're going to do, and they're going to test their opportunities. They're going to be testing this court as hard as they can to see what they can get.
So let's turn to abortion while you mention it. I think this is the area that those of us who do the civil liberties work are most worried about in the switch from Justice Ginsburg to Justice Barrett. You are one of the national leaders in the area of reproductive rights and freedom. Prior to your becoming a deputy legal director and expanding your areas. You were our RFP director. So what's new? We've got a medication abortion case that's going through the lower courts, and what do you expect there?
So I will say that I don't have the same optimism about the court and when it comes to abortion. The case you're referencing, there's a medication abortion case that's going to be back, expected to be back in the court in a matter of days. This is a case in which the ACLU challenged a requirement that that somebody seeking a medication abortion has to literally go to their doctor's office to pick up the pill. You don't have to take it in the doctor's office. You don't have to be counseled in the doctor's office. You don't have to have any kind of examination. You just have to go in to pick it up. And in the context
purely an obstacle. It's purely to impose
correct.
a
And we have a separate a challenge to that requirement sort of period, and then we have a COVID challenge to that requirement. The COVID challenge says, look, everybody's eased up on all these requirements. People are saying you don't have to take this risk to your health. And here there's not even a reason. So we asked for an injunction against enforcement of this provision during COVID. And we prevailed below. Case went up to the Supreme Court. Supreme Court said, oh, we're going to send it back down so the government can say whether the circumstances have changed. The lower court just ruled yesterday in our favor again. I will say the government had the audacity to come in and say, circumstances have changed, it's now safer. And the issues about the obstacles posed by low-income women and women of color have been mitigated or resolved. That is literally what they said. The judge wasn't buying it. Now we're going back up to the Supreme Court with the feds arguing for a stay of the injunction. There are 15 cases teed up, like in the courts of appeals around abortion. And so I know I want to ask you some questions, Cecilia, turn the tide here. So I'll just say quickly, I'll be surprised if the court literally issues a decision that says Roe versus Wade reversed. That's in part because of what David said about social pressure. They understand that will create a backlash. But I think what we can expect to see, or we used to talk about chipping away, I think we can expect to see some real gutting. So I would really urge everybody to not look just for that headline about reversal, but to really pay attention to the gutting. And we have to up the game to make the court know that the heat is on and that there will be backlash for any of these decisions. So that's my quick.
Yeah. Okay, we're going to switch roles now. Oh yeah, go ahead.
Exactly. We're switching roles. We're turning the tables. You, as immigration expert, I know that there are 2 cases before the court now. Can you talk about what those are and what you see both in those cases and in the space going forward with this court?
Sure. The 2 cases that we have in the Supreme Court, in addition to the second census case, which Dale talked about, which is also an attack on immigrants, are on a challenge to Trump's, what I call his border wall boondoggle, his use of other funding for the Defense Department to build his beautiful, I have in scare quotes, border wall. And the second case is our challenge to Trump's forced return to Mexico policy, where people seeking asylum at the US-Mexico border were actually screened in by federal officials who found that these immigrants passed their credible fear interview, the first hurdle to getting asylum in the United States. But Trump has forced all of those people back to Mexico to wait for a decision on their asylum claims and their deportation cases in Mexico. The vast majority of those people are families with children who are literally living in the streets of some of the most dangerous regions in the world at the northern regions of Mexico. So those are the 2 cases that we have in the Supreme Court. I'll preface my comments about both of them by saying immigration is an area where the Supreme Court has always been challenging, always been hostile. At best, we had a 5-4 hostile majority, and the wins are few. And so in the realm of inside baseball, off the record comments, I would say that our strategy often in the realm of immigration has been to pick our federal circuits where we bring cases carefully and try to keep the cases out of the Supreme Court. So these two cases fall in that category. They're both cases where we won in the lower court in the Ninth Circuit in both cases, which is the Western United States. In the border wall case, just to remind everyone of the background, there was the longest federal government shutdown in US history over the border wall. Trump wanted about $6 billion to build 234 miles of new border wall along the US-Mexico border through some of the most precious public lands that we have in the United States, beautiful country, especially in the Rio Grande Valley. And Congress, after engaging in a deliberative political appropriations process, decided to approve only 1.375 billion, and they had certain limitations on the border wall. They made space for local consultation, and they said only in these specific places in Texas. Well, Trump wanted to have it both ways. He signed that appropriation bill, but at the same time he announced he was going to spend another $6.1 billion over what Congress appropriated to build more wall, including in places that Congress deemed were too environmentally sensitive or where there were too many people's interests at stake. So this case is about the first tranche of money he diverted from military pensions and support for US allies in Afghanistan out of the Defense Department's budget and into the Department of Homeland Security's border wall. And we won the case in the Ninth Circuit, but alas, the Supreme Court issued an order that basically lifted that injunction back in July of last year. And so much of the wall has been constructed. And the big fight right now in the court is whether the president has the power to transfer those Defense Department funds or not under both the Constitution and under the military spending statute that he's invoked. The second case, more briefly, is the one about the forced return to Mexico policy. This was the extraordinarily cruel policy that I described. Applies to everyone except for Mexicans who comes to the US-Mexico border seeking asylum, and had the Orwellian name of migration protection protocols. Thousands of asylum seekers have been affected. Many of them are in the Mexican state of Tamaulipas, living on the street in tent cities. And we also we got a victory in the Ninth Circuit, but then the Supreme Court stayed that lower court order in March of this year. Both of these cases are ones that we hope the Biden administration will make go away by rescinding the policies. The trick is they're both on a fast track. The argument date hasn't been set yet, but both of them are likely to be argued in the last week of February or in early March. The briefs are due January 12th and 13th, and the fear is that there won't be time to fully settle those issues. So that's what's going on in the two immigration cases at the court. We're out of time on immigration. I want to switch now and invite our supporters to ask us questions. Makiba, do you want to give everyone instructions? I see that we're doing this through the chat function in Zoom now.
Yes, that's correct. Thanks, Cecilia. If you have any questions and would like to ask your question aloud, please use the raise hand feature found at the bottom of your screen and we will unmute you. If you are joining us by telephone today, please dial *9 to raise your hand and we can unmute you that way. Otherwise, please enter your questions in the chat function found at the bottom of your screen.
And Makiba, will you read out, let's take maybe 3 questions at a time so we can try to fit in as many questions as possible.
Sure, give me 2 seconds.
Or Jeannie. And welcome back, David. Dale, you wanna turn your camera back on so we're all on? Thank you. Okay, while we're waiting for the questions to be teed up, let me throw out the first one. Let's see. Louise, I've got another one for you. I think a lot of people's eyes are on the big ACA case in the court. You have been really, I think, the biggest proponent of establishing the idea that healthcare is a human right and is centrally about civil rights and civil liberties because it is the antecedent to exercising other rights. What's at stake in that ACA case, and what did we say in our amicus brief in that case?
I think the ACA is at stake in the ACA case in the sense that's certainly what the parties are. It's a very interesting case in the sense it's called, the caption is Texas versus California. So Texas and other states sued, arguing that, you all may remember the talk about the individual mandate. Once upon a time, there was a challenge to the individual mandate back in 2012. The Supreme Court rejected the constitutional challenge to it, saying it was appropriate within the taxing powers. In 2017, Congress zeroed out the penalty attached to the mandate. And so states have come back to say, well, now that there's no penalty, it's clearly not justified within the taxation powers. And if it falls, the entire ACA must fall. We filed a brief this year, this time, talking about the essential nature of the ACA to people living with disabilities. I'll say more broadly that, I'm on record as having said I think that the ACA is the most important civil rights act of the 21st century in terms of eliminating discrimination in healthcare based on sex, in terms of eliminating discrimination based on pre-existing conditions, banning caps on how much services you can have. And so the brief talks about the importance of what the ACA does for the health and independence of people with disabilities, and says, you know, if Congress, if the individual mandate went away, Congress didn't mean for all of those services to go away. What I find quite interesting is every single news report says they think, even if the court were to say that that the parties were appropriate parties to bring the case, they had the appropriate injury to be before the courts arguing this. And even if they say the individual mandate falls, all the predictions are that the court will not strike the ACA. The ACA will survive this case. But I do think it's important for us to be seeing the many ways, including very explicit ways, that the ACA is an anti-discrimination measure.
Okay, Makiba and Jeannie, do we have some questions lined up from?
We do, Cecilia. So
Great.
we have a lot of questions around litigation for the election results. And Ted B has a question: new measures to restrict voting in Georgia for the runoffs. Certain counties are losing polling sites. Another question from Elisa G: what is your opinion about the Supreme Court taking up the AG Paxton from Texas case now that 17 states and 106 congressmen have joined? And another question from Neil T: why is the census issue even a question? The Constitution clearly and ambiguously says enumerate persons, and persons I think is in bold for Neil.
Great. I think, Dale, those are all for you in the first instance. Take it away.
Sure. Let me start with the Georgia runoffs. There are already some disturbing reports about polling place closures in a number of counties in Georgia. We're watching those really, really carefully, and we're going to do what we can to try to make sure that access is not unduly restricted in the upcoming runoffs. More longer term in Georgia, I'm concerned about legislative changes that are going to cut off the means of participation that people used in this election, and disproportionately the groups of voters, Black voters, other voters of color, that produced the outcome in the presidential contest there. So the restrictions on absentee voting in particular, that's something we're going to be looking at really, really carefully. There was a push on this issue in Michigan after the 2016 presidential election, and notwithstanding a Republican trifecta in the state government there, we were able to successfully advocate to prevent the imposition of new restrictions on voting. So that's going to be the first step, try to get this stopped in the legislature next year, and then if not, we'll look at what kind of litigation options we might have depending upon what actually passes. But I guess before that, we should also talk about the presidential election. So I think folks have seen the incredible string of losses that the Trump campaign has racked up over the last few weeks. I think at last count, they had lost something like 51 or 52 decisions since the election a month ago, which is really quite something. I don't think I've ever witnessed a string of a losing streak like that in court before. They're not getting anywhere. These cases aren't going anywhere. We participated in a few of them where we thought it was particularly important to defend people's ballots, make sure that they didn't get tossed in places like Pennsylvania in a case that's now over. But now we have this case that the state of Texas has filed, right? Suing Pennsylvania, Michigan, and Georgia. 17 states have filed a brief on Texas's side. More than half of the Republican members of Congress have done so too earlier today. And it's really an unprecedented attack on democracy through the litigation process. I mean, this is nothing more than those states' attorneys general and Texas and those Congress people suing because they don't like the result of the election. That case goes directly to the Supreme Court as disputes between two states do. There was a famous case a few decades ago between New York and New Jersey over, you know, the famous island in the New York Harbor. So the case has to go to the Supreme Court first, but I don't expect this to go anywhere. It's a political ploy. I'm not worried about the legal outcome of this case. It's really laughable, both factually and legally, and I expect the Supreme Court to dispose of this case really quickly. The threat that this case and the incredible support that Texas has gotten is not a legal threat. It's a political one. It's where a good chunk of one of the two major political parties in the country is signaling that it does not believe in elections anymore, that any election outcome that they do not prevail in is inherently suspect and illegitimate. And that's a bigger problem of our political culture, not a problem of our, not a problem that I think we can litigate our way out of. It's a problem that we're going to have to confront together as a society. The last question I think was about the census. Yeah, this is by far the most blatantly unconstitutional thing I've ever seen. The Constitution requires that the division of representation in the House of Representatives be based on the number of persons in each state. It's hard to make any kind of argument that that does not include all immigrants, including undocumented immigrants. The Supreme Court held in a case in the 1980s that whatever you can say about undocumented immigrants, they are clearly persons under the Constitution. That remains true today. And I was heartened by the fact that even some of the most conservative members of the court seemed very, very skeptical of the government's position during oral argument last week. As I said before, I can't imagine us losing this case on the merits. There's a chance we're going to hit a speed bump with the timing of the case. And if that's what happens, we'll see them right back in court. But this is, I think, an example of the kind of thing that we can win even with a conservative Supreme Court. Our argument's based on plain text. I had to read more dictionaries for this oral argument, more 18th century dictionaries than probably I have in the rest of my legal career combined. But we have, I think, the kinds of arguments on issues like this, the same way that we did in the Bostock case that David argued in the Supreme Court on LGBTQ rights and to be free from discrimination in the employment context. We can win with this court. Certain cases, we just have to kind of change our approach a little bit, and I think we're already doing that.
Okay, thanks, Dale. Makiba, give us 3 more, and we're going to switch back from give Connie a break. Clint's back with us.
Sure. So I have a raised hand question from Ronald D. Ronald, I'm going to unmute your mic. You should be allowed to speak your question aloud.
Yes, I was just going to comment on Mr. Ho's presentation to the court. I happened to stumble across it on C-SPAN, and I was totally impressed with his performance there. And I think the justices were. But my question to you, Mr. Ho, is what's the best outcome? Will they redo the census if you get a favorable outcome?
There are some cases in the pipeline, not ours, that are asking for some better quality control measures with respect to the census. There are really big concerns that the pandemic disrupted census outreach. The administration cut outreach short by a few weeks. And I think, we don't know at this point, because we haven't seen the numbers, what kind of accuracy issues there might be. And there are a few cases, that would seek to address that. Our case doesn't deal with that. It deals with just the simple issue of whether or not every person, as the Constitution requires, is included in that census count that's used to divvy up the House and to allocate votes in the Electoral College for the next decade. So the best outcome is we win this case decisively. The Supreme Court says immigration status is completely irrelevant to that question, and the administration's plan goes out the window, and the census numbers that include everyone will be the starting point for divvying up the House. There may still be some other litigation to try to make sure that those numbers are accurate. Other organizations like the Lawyers Committee for Civil Rights and the Brennan Center are doing great work on that particular issue, but we're just trying to make sure that no one is excluded from the count based on their immigration status.
I'm going to preempt Makiba because I see a question from David Fidenki, our old colleague, retired former executive director of the ACLU of Oregon. And I'll toss this one to David Cole from David Fidenki. He says he's asking about the Supreme Court's shadow docket and writes that it's greatly expanded and the court is intervening much more to mess with the victories we've won in lower courts. You've thought about this. What are your thoughts on, how is that affecting our work, and is there anything that could be done about it?
Okay. Yeah, the shadow docket is a term that is used to describe the process by which the court decides, sort of on a very fast track, requests by a losing party in the lower courts to stay an injunction that was entered against them. And, Cecilia talked about the border wall case and the return to Mexico policy case. Those are 2 examples where we won in the lower courts. We won in the Court of Appeals. And then they went to the Supreme Court and got a stay. And when the government does that and the court does that, it's done extremely quickly. There is no oral argument. There's very rarely any amicus briefs filed. And the court, most troublingly, the court doesn't have to give reasons for its decisions. It just announces the decision. It can give reasons, and very occasionally it does. But in the vast majority of cases, it doesn't even give a reason. It just says stay is granted until further notice or until the cert petition is fully dealt with. And sometimes you see dissenting justices write opinions about why what the court did was outrageous. But one of the real constraints on a court, these justices are appointed for life. They have incredible power. But one of the constraints on them, and probably the most important constraint, is the rule of law. The idea that you have to explain what you're doing, you have to explain it by reference to prior precedents, and then you have to be bound by those precedents going forward. But if you can issue decisions without giving reasons at all, then what's the constraint? And we've seen this in the death penalty context. We've seen it in the COVID context. We've seen it in the abortion context. It's a very, and the immigration context, very disturbing trend. And it's been expanding rapidly under the Trump administration, has filed more of these requests than ever before, and the court has granted more.
Okay, Makiba, give us another, we'll take one more round of 3 questions.
All right, sounds good. So we have one here from Norma S. Are there ways the Biden administration can protect voting rights that will override some of the mischief in the state legislatures? Another question from Jeff R. Any impressions of Judge Barrett at this point? Any chance she will depart from the arch-conservative, anti-abortion, anti-climate change, anti-etc. version presented by the media? And then lastly, we have a question from Susan G. Aside from donations, how else can we encourage change in these issues and cases, especially for those of us residing in states with Republican representatives?
I'm gonna start by kicking the Justice Barrett question to any of the 3 of you. Why don't we start with Louise, since Justice Barrett is presumed to affect her issue areas most especially. You're on mute.
Some days that could be good. I'm a little hesitant to say too much. Justice Barrett, I think, has 2 opinions where, I mean, she signs on to 2 opinions in the abortion space, which are don't leave me optimistic. Now, obviously, she's been on the court only for a number of months, but in the abortion space, I'm definitely concerned. I haven't seen anything in the LGBT spaces. I think in the religious freedom space and in the religious exemption spaces, or just religious freedom in general, there's already enough of a move in the court to be sort of revisiting, and they've already taken quite a few actions to sort of be shifting religious liberty doctrine. I expect her to be in that space as well, and we'll see how far that goes. But it feels, if you're holding out hope that, oh, maybe she'll be somebody different from who we think, too early to know for me.
David, what do you think?
I agree with that. I think, you know, that she was picked to be a reliable conservative vote, as was Justice Kavanaugh, as was Justice Roberts, as was Justice Gorsuch. But I think what history shows is that you can't really judge a justice until they're on the court for a number of years. That they often, shift in some way or another, and many Republican-appointed conservatives have moved towards the center while the court had a majority of conservatives. And I don't think that's an accident. I think that's because the court as an institution has an interest in sort of being somewhat centrist and being open to arguments on both sides so that people continue to believe in its legitimacy. That's important, and it works to our advantage when there's a conservative majority. So, for example, 2 terms ago, every conservative justice on the court departed from his colleagues, his conservative colleagues, and joined the liberals in a 5-4 case to give the liberals a victory. It happened 8 times. Every justice did it once. 1 justice did it 4 times. The one who did it 4 times, you're probably thinking is Roberts because he's getting all the credit these days, but no, it was Justice Gorsuch. So I just think it's too early to tell. I'm not holding out lots of hope, but I'm not writing any of them off until I have a lot more data.
Yep. And Dale, can you quickly answer Norma S.'s question about, are there ways that the Biden administration can protect voting rights, or is any federal intervention have to be a legislative one?
No, there's a lot that the Biden administration can do on voting rights, even without action from Congress. I mean, the first thing, and it's the simplest thing, is they can actually enforce the Voting Rights Act. The Trump administration brought 1 case under the Voting Rights Act in 4 years. That has never happened since the Voting Rights Act was enacted in 1965. That low level of activity. So just having a normal Department of Justice is going to do a lot. There's a lot more that the Trump administration can do. We're that the Biden administration can do, excuse me. And I know our Washington office is hard at work right now on a list of asks that the incoming administration can do without legislation right now with the stroke of a pen by President-elect Biden once he's in there, and I'm sure those will be public soon.
Yep. Okay, we're going to end with Susan G's outstanding question. Aside from donating money to the ACLU, what can you do? Lightning round. I'm going to have all four of us answer it. I will start. You know, on immigration, I think we've got a lot of work to do to shift public opinion. Our concern is that the Biden administration is not going to both repair the damage that Trump did and make progress. The Obama administration is famously spotty, had a mixed record when it came to immigration policy. And it's for the reason David elaborated on. It's that the bulk of the American people are not yet where we want them to be, and therefore elected officials aren't where we need them to be. And so I think what all of us can do, whether you're an ACLU lawyer or a doctor or a custodian, is to have those conversations with the people that you know and love, and work these things out. And that's my offering. Dale, what do you say?
Well, I know for Georgia and for the runoffs, which a lot of people are interested in, the Georgia affiliate's going to be doing a lot. They had a very, very robust and active program for the presidential election, both recruiting poll workers, there's a huge poll worker shortage that they were able to really help fill the gap on. I'm sure we're going to have issues with that again for January because most poll workers, historically speaking, have been over the age of 60, and those are exactly folks who need to be social distancing right now. So take a look at the Georgia ACLU's website for information on how to volunteer to be a poll worker if you're so inclined. And then there's other work that they've been doing on voter education and GOTV efforts all through them. I think and these days, with so much of that work being remote, I think you don't have to be in Georgia to do all of that the full range of civic activism that supporters of Georgia affiliate have done in the past. So definitely check out what they're doing in advance of the runoffs.
Louise, what's your advice?
So I've seen different strategies. I think of Indiana. So Indiana, when Mike Pence was the governor, became a really active state in terms of opposing anti-LGBT measures. And a bunch of that was driven by businesses. So I don't know who all of you are, but the ERGs, the employee resource groups within businesses, had done a lot of push internally to change reform practices. And then businesses became real leaders. And I think we used to joke it was the businesses and the sports teams that were the greatest advocates, successful advocates for LGBT rights in the states, in conservative states for us in a number of places, and really switched to the governor's perspective. So I'm using that as an example of different ways to organize different constituencies. Back to David's point, having people understand that there's a cost, whether it's the state government or having the feds understand that there's a cost to like saying yes to abortion bans in Georgia. There's a cost to saying yes to abortion bans in Alabama, I think really matters. And it's easy to feel defeated, and it's essential not to feel defeated and to lift up voices of people.
I love that. David, we could just say, read David Cole's book, Engines of Liberty. But what do you have to say to us now?
So I think you could read my book. You could also read the quote that I begin my book with, which is from Learned Hand, a judge on the Second Circuit in New York in the 40s and 50s, and he gave a speech on the topic of liberty, and he said, "Liberty lies in the hearts of men and women. When it dies there, no court, no constitution, no law can save it. While it lies there, it needs no court, no constitution, no law to preserve it." Now, that's a bit of an overstatement. I think we need courts, we need a constitution, we need laws. They remind us of our, commitments to our better selves. But it's a profound truth that at the end of the day, liberty depends on us, on all of us. And so what does that mean for the folks on this call? I think what it means is to support and get engaged in those institutions and movements that are advancing the values that you care about. I mean, marriage equality was won by a handful of groups that were committed to the dignity, the equal dignity of LGBT folks, and they, you know, enlisted citizens across this country in that effort, and that's how change happens, right? And so, you know, I think about the Women's March. I think about the Black Lives Matter protest. I think about all the protests in favor of the Dreamers that we have seen in the Trump era. I think about our grassroots efforts at the ACLU under the rubric of people power, which is designed to allow ordinary folks in their local communities come together to stand up and defend civil liberties. And if we do that, you know, again, going back to that political science research that I referred to earlier, the court will follow. So we need to all be as engaged as we can and support those others to be engaged in the fight. And if we do that, we can make progress. And if we don't do that, the courts won't save us.
Yep. I think, you know, the bottom line is that whether we win or lose in the courts, our work is meaningful to the people that we represent and serve and stand up for and stand with. And, you know, to give another example, in addition to helping people cast their votes during an election during COVID, we got hundreds of people out of jails and immigration detention centers during COVID. And each one of those people's lives were changed for the better, maybe even saved. So thank you all. Thank you so much for being our most stalwart supporters and for listening and engaging with us and for everything you're doing to support us. Thank you. Thank you.
Thank you.
Bye-bye.
Bye.
Thank you. Bye.
So much.
Thank you, everyone, for joining us for today's Supreme Court briefing. If you have questions we were unable to answer, please email us at leaderforum@aclu.org. Thank you and have a great day.